Namaskar. We are delighted to inform Symbiosis Law School NOIDA, in association with Lex Witness, India's first magazine on legal and corporate affairs, THS, the law firm, and Sadgamaya presents Knowledge Series on Law and Justice. The Knowledge Series aims to provide continuing legal education to the members of the bar and to provide an opportunity to the students of the law school to learn from the best and the most experienced legal luminaries and have first-hand experience of interacting with them. Today, we have among us Ms. Geeta Luthra, Senior Advocate, Supreme Court of India. Ma'am requires no introduction, but it's the ritual which I shall fulfill. Ms. Geeta, Senior Advocate, Supreme Court of India, has completed graduation in law from Faculty of Law, Delhi. She is recipient of INLAC scholarship twice, first to complete LLM and then MPhil from prestigious University of Cambridge, UK. Ms. Geeta is an independent arbitrator specializing in complex international and domestic commercial arbitration. She has over 35 years of experience at the bar dealing with specializations in myriad facets of law such as environmental law, human rights, family law, commercial disputes, international and commercial arbitration, constitutional law, criminal law, intellectual property law, copyright, including copyright patent, service law, banking law, property disputes, private international law, to name the very few. Presently, Ms. Geeta is Additional Advocate General for the state of Haryana in the Supreme Court of India. She has been Senior Counsel for Union of India from 2014 till date. She has served as Standing Counsel for Union of India at the High Court of Delhi from 1999 to 2004. She was Special Standing Counsel for the Land Acquisition Department and have done numerous arbitrations for the government for properties requisitioned by the Government of India. She has argued several matters for Union of India and Government of National Capital Territory of Delhi involving state police and customs and excise matters. Ma'am also has served as a Special Standing Counsel for the Union of India in several environmental matters. So there is much to say, but I would like to thank Ma'am for accepting our invitation to address the gathering. I would request Mr. Rajkamal, Advocate on Record, Supreme Court of India, who would moderate the session, to take it forward. Over to you, Raj.
Thank you, sir. We are honored and privileged today to witness the webinar on PMLA Act by one of the most eminent senior advocates, Mrs. Geeta Luthra. Ma'am, on behalf of the organizers of the Knowledge Series on Law and Justice, we welcome you and all the participants to the webinar. Ma'am, before we begin, I would just like to put the housekeeping rules for all the participants. This session will go on for an hour and a half. And whoever wants to, the participants could ask their questions by putting the questions in the Q&A box. And ma'am will address the issue when we ask her the questions. And also at the end of the webinar, there will be a live question and answer session. So whoever raises the hand icon, we will put you in the queue and then we'll put the questions to ma'am. So we'll try to address as many questions as possible. Ma'am, over to you, please.
Thank you. I enjoy always coming to Symbiosis, NOIDA, and it is my misfortune that today we are doing this online, but we'll make up in better times, I promise you, because I love coming to your institution. I love coming and meeting the students. I love learning from the students because one of the, I used to sit on several interview boards for scholarships. I still sit on a few. And I always come back with the feeling that you students know much more than we do, and that I have no business to be sitting in that chair. I should be sitting across the table being interviewed, and you should be firing the questions. But thank you for listening to me and being with us on a Sunday afternoon. Thank you so much. I'm going to speak about PMLA, that is the Prevention of Money Laundering Act. And Mostly I will speak through a slide, except where I may transgress on the facts of certain cases, just so that the students, all of you, have an overview of what I'm saying. So first, most interesting aspect which I wanted to share with you was some recent cases on PMLA. As students of law and as lawyers, every day that we open the newspaper for the last many months and many years, what we are reading about are really cases of money laundering and offenses in which prosecution has been launched by the Enforcement Directorate, which is the directorate in charge of money laundering offenses and complaints under money laundering. So every day when we open the paper, we read about cases which are so real and which are so near to us. So yesterday's icons, yesterday's poster boys become today's accused in cases of money laundering. As you would know, and you would have read the papers, one of the latest cases was about a week ago, where the aspect that has come by the Delhi High Court is the fact that earlier owner or controller of Fortis Hospital, Religare, Shivinder Singh, the court has held that he's been inside custody for 1 year, 2 months odd, and therefore he should be given bail in the money laundering cases launched by the Enforcement Directorate. About 4 days ago, I want to read and quote to you the scathing terms in which Justice S.K. Panigrahi of the Orissa High Court has referred to bail being rejected for a person who was accused of money laundering. The offense was of some 700 crores of a Ponzi scheme. I'm sure that as students of law, you are aware of Ponzi schemes where people put in monies with the hope that they will get these huge returns. Now, there are two sides of a coin. There is, of course, a country where we know that people are by and large illiterate. People are taken in by these attractive schemes, which are offering a pot of gold at the end of the tunnel. But on the other hand, we have to look at the other viewpoint. Why should people be so gullible? Ultimately, if I am promised that for 1 rupee, I will get a pot of gold, my antenna should also be raised. I should also be thinking, will this scheme, can there be such a scheme offering a pot of gold? But ultimately, the Money Laundering Act, Prevention of Money Laundering Act, is not about investors or persons who have been greedy, if I call it that. It is about bringing to book people who are guilty of money laundering and of siphoning monies of innocent persons. I want to start by quoting that judge because it's really scathing the way the court has, the Orissa High Court dealt with it. It's of 15th July, about 10 days ago. The offense of money laundering is nothing but an act of financial terrorism that poses a serious threat not only to the financial system of the country, but also to the integrity and sovereignty of a nation. Justice Panigrahi was hearing a bail plea of a director accused of involvement in laundering sums of money in a Ponzi scheme. Then the court goes on to say, the modus operandi adopted while transferring such prodigious sums of ill-gotten wealth with the singular intention of concealing the original source of funds and to project the tainted money as untainted ex faci constitutes the offense of money laundering. I'm thinking of Justice Denning when I'm reading all this. The aforesaid amount of money has been moved around and subjected to Machiavellian layering through a myriad of shell companies and bogus transactions. And then he goes on to talk in even more eloquent terms about the fact that about 590 billion in the international world, or $1.5 trillion, which is 2 to 5% of the world's gross domestic product, is all subject of money laundering and consists of laundered money. Now let me go to my PPT and show you that. You call Shivani. Just give me a minute and I will open it. Is the screen being shared? Can I open it?
Ma'am, if you wish, I can run the slide for you.
Can be, but then we will, I'll just tell you when to pause. Is that all right?
Yes, ma'am, I'll do that. You just have to stop share. I will share it with you.
All right, all right. Sorry, it's come on. Sorry, thanks.
Okay.
Yeah. So, first wanted to start by telling you that, telling the students that the malaise of money laundering has been a challenge to the global community. And the first act on this is in 1986 by the United States of America. But there were two international organizations, the European Commission and the Gulf Cooperation Council, which formed what is called a Financial Action Task Force on Money Laundering. And this was with the objective of development and promotion of policies to combat the menace. Now, I wanted to pause here for a minute to say that the principal objective of the Money Laundering Act was essentially to have forums of cooperation where there would be international standards and policies to combat money laundering, and principally in two aspects. One is terrorist financing and the other is drug money. So that were the two major objectives. Provide a comprehensive set of measures to enable all countries to implement effective anti-money laundering, counter-terrorist financing systems that will protect the worldwide financial system from misuse by organized crime and terrorist financiers. Now, this objective has largely been achieved by this act. So this was in 1989, and we had the enactment in 2003, which came into force on 1st July 2005. Now there's been no going back. It's just becoming, the net is becoming wider, the net is becoming more stringent, the net is, and in the scheduled offenses, which were earlier very few and very serious offenses, now we have been adding more and more and more. So much so, aspects of, very recently, aspects of the Companies Act 447 have been added, of which there is a major criticism that's happening. There is Prevention of Money Corruption Act, which have been added all in the 2018 amendments. So the question here is, how much do you increase the enactment? How far do you increase the enactment in such a manner and widen the net so that it becomes so wide that that it becomes all-encompassing, and to my mind, it dilutes the very purpose of the enactment. So what happens is that the moment that you have an enactment which goes beyond the intention and purpose, then you are making an extremely strict law for purposes where you in fact wanted the act to be very forceful, but to be limited to those few offenses. Now, even less serious offenses have been added. And what I would want, and what the purpose of this discussion will essentially, apart from talking of the fact that the Prevention of Money Laundering Act has two parallel processes, as you'll see in the slides. One is the adjudicatory process, the other is the prosecution process. What you'll be seeing is that how the prosecution process has become such that the prosecution is so burdened in favor of the state. The onus is so changed in 23 and 24 of the Act. The bails are so anti-petitioner that is it something which was supposed to be the purpose of the enactment? Come back. Yes. Now, if I can go on after reading this para to the process under PMLA, which is what I was just talking about. Trial under section 3 read with 4, this is the prosecution, and the adjudication process, which is under 5(8) read with 17. So first, let's look at the left side. This commences with the registration of what is called a ECIR. It's done by the Enforcement Directorate. And this is, in its turn, based on a person accused of a predicate offense. Now, for those who are not familiar with the PMLA, a predicate offense is a main offense. Suppose you are accused of an offense under terrorist activities. Suppose you are accused of an offense under NDPS, Narcotics Act. That becomes the predicate offense. The offense under PMLA is based on the schedule, which is at the back of the Act, where Section 3 is the principal section and Section 4 is the punishment section. Now, the other aspect, which is on the right side, you'll see that is Section 5, 17, and 8. So 5 deals with provisional attachment. So basically, if you think that some money is tainted money, you can provisionally attach it for a period of 180 days. Now, if we look at the Satyam case, about which I will talk later, but I'll give the facts. Mr. Raju, who was the founder of Satyam, and Satyam stocks rose exponentially. It was the first IT company that did brilliantly in India. It was one of those poster boys cases, but he found that between their monies as well as what they were projecting, there was some difference. So they started fudging the accounts initially by a very small amount. Later, they fudged to a large extent, showing properties which were worth X amount as being X into 8 or X into 10 amounts, only in order to keep borrowing and justifying the borrowing and justifying the market rates and the shareholders, the shareholders' confidence. Now, the case that came before the Andhra High Court was a case under the adjudicatory process. And the question that arose was that would this aspect of the burden of proof under 2324, which I'll talk about later, whether that will whether that would equally apply to the adjudicatory process, whether this whole onus issue is only for the criminal law or is it also for the civil law. The other aspect was that Satyam started a company in his son's name called the opposite of Satyam. So Satyam, that was called Maytas, Mayatas or whatever. He tried to take over that son's company at a huge amount. The other directors objected, and that's when this whole thing happened. And he wrote a confession letter to SEBI as well as his shareholders. He later then withdrew that because he realized that this is going to be a problem. So his lawyers must have told him, what blunder are you committing? So you are the delight of the prosecution or the state if you make an admission in law. And half of law is about how admissions should be inadmissible and how they should be admissible. Prosecution trying to show that they are admissible and the defense trying to show that they are inadmissible. Now, let me show you how an offense is supposed to happen. So there is a predicate crime, corruption, fraud, organized crime, drug, environmental crime, terrorism, other serious crimes. A little bit more about these predicate crimes later, because when I talk of 45, I will talk about the fact that organized crime under MACOCA, NDPS, PMLA, which is the present act, and now SFIO recently, and the Supreme Court having opened it once again for being re-examined, all these have these twin conditions under 45 of reversing the burden and turning it on its head, as Justice Nariman says. So we come a little more about this later. The second part is placement. So assume a case that you have a case of, say, helicopters. India needs helicopters. So it goes to company Tin Min, assume its company is called Tin Min, and then decides somehow the other, and various reasons, the tender is floated, the conditions are there by the Defense Ministry, and it says the Tin Min is the best company to give this contract to. But there are middlemen, and those middlemen are getting a commission which is not allowed in law. That results in the helicopter, which should cost 500 crores to cost say 600 crores. So there is 100 crore add up. That 100 crore add up then is routed back to those middlemen who have helped procure the contract. So there is placement. Now, this is the most vulnerable stage in money laundering. After that is layering. That 100 crores comes to FinMin, will give it to whom? How does FinMin make it ensure that this will go to the middleman as well as the person in the defense or the concerned ministry, that he will get or his relatives will get a portion? So what is done is, you first send it to the Cayman Islands, you may send it to Mauritius, you may send it to any of those countries, you may send it to any part of the world. Then slowly you have to bring it back to the person who may be in India, or who may be in England, or who may be in Mauritius. So how do you layer it in such a way? How do you use it, say, to show that you are giving a service so that you are being paid legitimately? So there are countries and countries where no questions are asked. So people will try and send the monies to those countries, and then you integrate it back such that the person who is the middleman will get most of the monies either himself or through his relatives or through purchase of properties. So then it comes the integration stage. Now, after the integration, the question which is the concern of the prosecution is to bring home the guilt. The question of the civil offenses, how to attach the monies, how to ensure that those monies are then taken by the exchequer, that the exchequer then confiscates that money. To confiscate that money, the exchequer has to, the state, then what is appointed is, there is a provisional attachment, and then there is a adjudicating authority. In 180 days, the adjudicating authority has to confirm that attachment. He is a quasi-judicial. So first is an executive body, then is a quasi-judicial body, and then it goes to the appellate body. The appellate body has normally been a judicial officer, a retired High Court judge. So normally the way the process has gone, and I've seen cases where a person has said that I bought this jewelry 100 years ago, it's my parental jewelry, I have proof. I have wealth tax returns showing that this jewelry belonged to the family many years ago. It can't be part of your attachment. But the fact is that because you're talking to executive and quasi-judicial bodies, they may not perceive it in the same judicious manner that a judge may perceive. Because if a judge sees that this is unconnected, he'll say, sorry, the provisional attachment is not confirmed. There has to be an opportunity given to give replies. all that is done, evidence is given. But because the appellate authority is a judicial order, officer, the chances of getting relief from the appellate authority are much higher. Now to come to this chart. So there are financial intelligence units, there is investigation by the Enforcement Directorate, and then you can see there's a fork, there's a complaint to the court, there's provisional attachment, and that's one process. Now, there will be 2 criminal cases. There's not one criminal case. Question is, should they be decided by the same person, same judge, and should they be combined? This is something which has vexed the state and the legislature, as a result of which the state has in fact made several amendments. By the legislature has made those amendments in order to enforce and ensure that both can be tried together, because defense counsel, being defense counsel, will say, all right, both should be heard together. What if I'm acquitted in one and discharged in the other? What if there is no proof that this is laundered money in the other one? So I should not be prejudiced. So now more and more they've said both can be tried, both to be tried by a special judge, but have to be tried as separate cases. Now, normally the predicate offense is either a CBI RC, or it may be an FIR if it's a penal code case or any other case which is cognizable. Now, insofar as an ECIR is concerned, what is normally done is a complaint case in the jurisdictional court. Now, if there is no conviction for money laundering, then that tainted money, alleged tainted money, gets released. But if there is a conviction, then there is a confiscation of that so-called tainted money. Now, the advantage of PMLA. I'm sure that you people are well aware that there used to be discussions, all right, so-and-so has money in Swiss accounts, can't be touched. So-and-so, that money is a secret code, Swiss banks won't tell. So because of this FATF and this decision to cooperate with each other, the cooperation has become shocking. Probably, if I recall correctly, in Beaufort's case, there were letters and letters written. No replies would come. I remember, if not incorrectly, Mr. Arun Jaitley and that whole, the people who were trying to prosecute it actually took a trip outside to try and see whether they could elicit cooperation. In today's day, the cooperation comes on a platter. You write later, you get a letter before. Now, this is something which all businessmen are very unhappy with. This over cooperation is not something which they want. Because what has happened, the practice has become, you write a letter rogatory, and that letter rogatory may be irrelevant. It may be saying, give me not the details of the accused, give me details of the accused mother's, brother's, father's friend. But the prompt comes a reply with all details. So I think both are necessary. There should be an accused, there should be material against an accused, and then there should be cooperation. But somehow you see that the cooperation has becomes so much. We have to ensure privacy where people are not accused of criminal cases. We have to ensure cooperation where they are accused of criminal cases. But the fact is that the overseas cooperation by India, by other countries, has reached because of terrorist crime. Because every country has a stake to ensure that terrorist crime is reduced. Every country has a stake that the integrity and sovereignty of that country is not undermined. Because of which the cooperation has fortunately reached levels which are extremely, what I will use the word, efficient. So now the last two aspects of this slide, burden of proof on accused to prove proceeds of crime are untainted. This aspect, as I said, I will talk about just now. In criminal law, the burden of proof has always to be on the prosecution. It should not be changed unless in the most extreme of cases. Now, in sometimes bad cases lead to bad examples and bad precedents. For terrorist crime, when the matter came before the courts, because they were terrorist crimes, the courts said, yes, the burden of proof can be different. But that upholding of that constitutionality has affected the burden of proof in PMLA, in SFIO, and the justification is that these are heinous economic offenses. Whether heinous or not, economic offenses or not, it is very difficult to prove a negative burden of proof by a person who neither has the state machinery nor the ability, when he doesn't even know the case against him. So the burden of proof is something about which I am saying that this works adversely to the victim, to the accused, and that is something which we need to look at when we look at 23 and 24, even though I've talked about it somewhat with regard to the Satyam case. Now, the statements recorded by ED officers being admissible as evidence. This also bothers me. The reason it bothers me, and it should bother all people who have a stake in the justice system, is that statements made to the police are inadmissible. The reason they are inadmissible is that third degree could be used, coercion could be used, persuasion could be used. For example, I'll give a case. A person is brought in by a department and he is told, you will sit here from morning to night, and in case you don't cooperate and say what we want, your pregnant wife, who is 9 months pregnant, will also be brought in morning to night every day. In case you don't cooperate, remember, you have a young marriageable daughter. Your daughter will be made and accused and she will be brought here every day. What will that man do? He'll say, whatever may happen later, let me at least write this and get them, save them. Then he may go back home after 10 days, his lawyers will say, have you committed harakiri? He says, I know I've committed harakiri, I've done it. His lawyers will say, now that you can just make a statement that you don't want to stand by what statement you have made. Or he himself will say, but I made a wrong statement. How can they hold me to it? They said, sorry, you'll be held to it. That's what the law is. So section 21U, I could read the definition of proceeds of crime because slowly it has become more expansive. Similarly, section 3, offense of money laundering, has become more expansive. It's still to be reinterpreted by the courts after the initial interpretation, after becoming more expansive. About 5 and 8, I have already talked. About 24 and 45, I will talk in a bit. I want to, before I go on to this slide, I want to read out section 2U for anyone who can look at it. Proceeds of crime mean any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then property equivalent to in value held within the country or abroad. So now you can see that the level of cooperation and the level of extraterritoriality. So the US law also has similar aspects of extraterritoriality, which, because even if a part of the offense is covered in the US has extended its tentacles over the money laundering. And as you can see, that there was an amendment in 2013 to enlarge the scope. So it deals with any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or value of any such property where property is taken or held outside the country, and then equivalent in value held within the country or abroad is the amendment. Now, I want to read out, since this judgment, Ramaraju's judgment, dealt with this in detail, I keep coming back to the judgment. Although there have been many, many interesting judgments and many people have come under the net. As you would know, the ILFS directors also on same aspects have come under the net. Now, one aspect which is not there in the slides, but which I would say, anybody who is dealing with government will know that government contracts take a long time for paybacks. The case which ILFS, for example, is setting up, I'm sure there are other transgressions by it, but one of the aspects that ILFS is setting up is this, that government owes us a lot of money and our money has to keep circulating. So the moment one cog in the machine gets stuck, our payments get stuck to those whom we owe. Therefore, don't blame us. You have to see where the money is stuck. So now I come back to that. One of them, one of the directors has got bail due to COVID, saying that in COVID times, because of health reasons, he should get interim bail. Others have not. And this is another issue which you will see as during this COVID period, that several of these persons are under trials who are sitting in jail simply because the allegations against them run into several crores, hundreds of crores, thousands of crores. And we as lawyers, as people who believe in the fundamental rights, have to see to what extent an under trial should remain in custody for whatever reason, even though if there are many zeros to his prosecution. Now, 103. Since proceeds of crime are defined to include the value of any property derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offense, where a person satisfies the adjudicating authority by relevant material and evidence having a probative value that his acquisition is bona fide, legitimate, and for fair market value, paid. Therefore, the adjudicating authority must carefully consider the material and evidence on record, including the reply furnished by a noticee in response to a notice, and the material or evidence furnished therewith, to establish his earnings. I won't read all of it but basically what it's trying to say is that if you are, and more of this later when I discuss the Delhi High Court case with regard to Axis Bank, which had given a mortgage and a loan, and the issue was, would the loan have primacy, or would the PMLA attachment? And the court said that if the bank has given a loan thinking it's untainted, not realizing after doing due diligence, then the bank's claim has to be given priority and has to be given regard. So basically what this is saying is that if it is bona fide acquisition of property, then can you still do an attachment? And clearly the answer will be no in most cases, as long as it's bona fide and it's with due diligence. This I have already referred to. So where the offense is not less than 3 years, we extend to 7 years/10 years, and shall also be liable to fine. In certain cases, offenses under NDPS, as you know, there will be rigorous imprisonment. So then the question is, will there be a limit? And that limit has been taken away. Now the power of arrest. There's a power of arrest, but very similar to what is stated in the Constitution. They have to be brought, produced before the court concerned in 24 hours and to be given the grounds of arrest. In fact, in practice, you'll see grounds of arrest are frequently not given. Now, as you would recall, in the Bhim Goregaon case, one of the allegations was that grounds of arrest not given, remand done improperly. But question is, does that entitle you to bail? Now the whole question has been reopened and is being looked at by the Supreme Court. One of the issues has been, would a habeas corpus be maintainable if you've done it under wrong premise? And the Supreme Court has recently, in the Jory case, said that this aspect also is something which the Supreme Court wants to examine. So the scope of wrongful arrest, as it is, as long as it's an arrest by the rightful authorities, is being narrowed by the courts. Now, question is how to be vigilant about the rights of an accused. We must remember one aspect as students of criminal jurisprudence, that every person is innocent unless proved guilty. And how will you get back those valuable years to a man who may be wrongly arrested? How do you get back his time? In India, there are no cases where people who have been arrested and acquitted after 10, 20 years have been given compensation for wrongful arrest. The moment this starts happening, we will start becoming more and more cautious about arresting people. Now, most important, when we discuss PMLA, when you discuss SFIO, when you discuss MACOCA, this aspect of Section 23 and 24 is the most important, and the aspect of how bail should be considered. Section 24 PMLA, and it's very important, that's why I'm going to read it out. In any proceeding relating to proceeds of crime under this Act, in the case of a person charged with the offense of money laundering under 3, the authority or court shall, unless contrary is proved, presume that such proceeds of crime are involved in money laundering. So there's a reverse burden of proof for a person who's charged with PMLA. As with several other cases and several other enactments, and those enactments and those presumptions are slowly on the increase. All crime is heinous, but all persons are innocent. So unless a person is shown to be guilty, he is innocent. And the question then of burden of proof should, as far as possible, be the burden on a prosecution. However, the PMLA makes an exception on the ground that these are economic offenses and the persons to be brought under net are criminals who will have international reach. There has been a debate as to at which stage the presumption comes into effect. Does it come into effect at the stage of bail? Does it come into effect at the stage of framing of charge, at the stage of registration of FIR, at the beginning of trial or final arguments? Supreme Court judgment in this regard in Kaliram versus State, which is not with the PMLA case, but is cases where it talks about the difference or the change of presumption in certain statutory offenses. And it says there are certain cases in which statutory presumptions arise regarding guilt of accused, but the burden, even in those cases, is upon the prosecution to prove the existence of facts which have to be present before the presumption can be drawn. Once those facts are shown by the prosecution to exist, the court can raise a statutory presumption. So there has to be some case with the prosecution so that the presumption arises. It can't be in the air that the moment I make a case and I give it this heading, the presumption has arisen. There is some satisfaction, some attempt has to be made to bring out the prosecution's case within the parameters of Prevention of Money Laundering Act, and only then will the presumption arise. The onus, even in such cases, is not as heavy as is normally on the prosecution to prove the guilt of the accused. And we once again come to Ramaraju's case. The Honorable Andhra Pradesh High Court, in the decision of Rama Reddy, was pleased to hold that the burden of proving that proceeds of crime are untainted property onto persons accused of having committed the offense under Section 3 is not confined to the trial of an offense under 3, but operates to attachment and confiscation. As I told you, Satyam was a case dealing with attachment and confiscation. This has been reiterated in Rakesh Manikchand Kothari as well as several other cases. So when you look at the judgments of the various courts, what we will notice that apart from Nikesh Tarachand Shah, the judgment of Justice Nariman's bench, most judgments speak before Nikesh Tarachand, and after Nikesh Tarachand, even despite the amendment, they are still saying that the legislature has brought an amendment trying to bring back 45 and the effect of Section 45 of PMLA. But despite that, the effect of Nikesh Tarachand cannot be whittled down, and there are 2 or 3 judgments by the high courts which have followed Nikesh Tarachand and said that the twin conditions as imposed in 45 won't apply. Now, Justice Gajinder Gatkar's court statement of finding in Izzar Ahmed versus Union, he says, the term presumption in its largest and most comprehensive signification may be defined to be an inference, affirmative or disaffirmative, or the truth or falsehood of a doubtful fact or proposition drawn by a process of probable reasoning from something proved or taken for granted. And he quotes the law of evidence by Best and says that even if there is a presumption which is rebuttable or irrebuttable, they are basically trying to give effect, attempting to assist the judicial mind in weighing the probative value. So what he's really trying to say is that even if there is a presumption, even if there is an irrebuttable or rebuttable presumption, fact is that you still have, the prosecution still has to prove its case. Now, I've already spoken a bit about the Section 24. I'm not going to dilate on this slide more. Now, just the normal law relating to burden of proof and its owners is given under section 101, 203 and 106 of the Indian Evidence Act. Burden of proof lies on the person of making a claim. Burden of proof normally lies on a prosecution. Now, with regard to section 45 of PMLA, I'm not going to read this slide. I will, let me see. I want to just read 45 for those who are not familiar with 45. Notwithstanding anything contained in the Code of Criminal Procedure, no person accused of an offense under this act shall be released on bail. So, this has been sought to be introduced by 2018 because originally what was envisaged is that a person who was accused of the predicate offense would have to satisfy these twin conditions. By writing under this act, they are saying even under the predicate offense and under this act, whether for all purposes. Shall be released on bail on his or her bond unless the public prosecutor has been given an opportunity to oppose the application for such release. So look at this. A court sees a prima facie case. The public prosecutor has not come with a response or needs time. And the court feels it's a good case. Even then, the court can't give interim relief. Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing he is not guilty of such an offense, and he is not likely to commit an offense while on bail. Now, how can a judge say, I will never know, maybe he'll commit an offense? So the kind of burden on the court was unreasonable. And this is what the Supreme Court said. It said, and what various high courts have said, they've said that you can't be presuming that he will be unlikely to commit. How can you form a basis? So the way the courts have interpreted it in certain cases, that the person should not have been convicted of an earlier offense like this. That's the only basis on which you can. And is prima facie that it's not guilty of such an offense? This is very difficult because till the prosecution has come in the court, so all persons are presumed to be innocent. Should it be meaningless, this line? Or should the presumption be, because the presumption is changed in 23-24, should in bail the presumption be, no, the presumption is he is guilty. So in Nikesh Tarachand, the Supreme Court said that section 65 makes the CRPC applicable. And therefore, you can't wish away the CRPC. And what is special about this case as compared to other cases, that you can't have the benefit of law and anticipatory bail or regular bail. And so the Supreme Court struck down these twin conditions as unconstitutional, even though as I said, the amendment has been brought, but the way the high courts have said is that in terms of judicial discipline, this striking down continues to inure despite the amendment brought by the 2018 Act. So this is the case I just talked about, habeas corpus, Raj Bhushan Om Prakash Dikshit. I think Justice bench headed by Justice Muralidhar heard the habeas corpus and then examined various aspects. Because while it says it's cognizable, when Mr. Chidambaram, the then minister, introduced it in Parliament, the amendments, he has said to make it bailable and make it non-cognizable or something to that effect. So the fact is this has now been clarified in the latest amendments, but this was a case against SBL, the biotech company, and one of its directors. And this case, although based on habeas corpus, the court gave stay of coercive steps. The ultimate manner by which the court interpreted was that based on the judgment of Union of India, National Federation of Blind, that your marginal note may be incorrect and it's your body of your case which needs to be seen. And what is, the body of the statutory provision needs to be seen, particularly where they are in contradiction. Ashok Munilal, I've just referred to section 65, and therefore that CRPC would be applicable. And so Supreme Court said it. Now, the one reason why I have let Rohit Tandon versus Rajkumar Goyal be in the slide is that it deals with an interesting fact. So as you would recall, the demonetization that happened in 2016 resulted in many people using their good offices to launder and change the tinted money or the old currency notes into new currency notes. A raid was conducted on a lawyer, Mr. Rohit Tandon, and ultimately he was granted bail by the Delhi High Court. Perhaps it was challenged, but the challenge was not sustained. And one of the aspects was that there were several crores of money which had been found, which was alleged to be then demonetized currency, which was, and therefore there was an offense being committed with regard to the Specified Banknotes Cessation of Liabilities Act 2017. Now, though the facts are relevant, the importance is how do you deal with cases of all hues under the PMLA, because originally it was few predicate offenses. The Schedule A was to which Section 45 was to be applicable was very narrow. Later it was expanded to become all-inclusive. How do you deal with bails and anticipatory bails in such cases? Mostly the courts in PMLA have not been giving anticipatory bails. one of the aspects in Augusta Westland which was brought up were the Tyagi brothers who were, he used to be in the armed forces, and they got bail in the CBI case and the ED case, which are normally made one after the other in a train so that the accused remains inside, which is, according to me, not a good practice, because when one is in jail in one matter or in custody in one matter, you can do the interrogation in the other also. But that's the practice. So there it was 60 or 44. Then for the other accused, you give bail in 60 days. Another accused, you give bail in 100 days. So how do you, and you keep doing complaint after complaint. Now, the original scheme of a law is that a criminal complaint should be one. There's no provision for supplementary criminal complaints. Now, this was taken up as one of the cases in PMLA. I think it was specifically taken up in Gautam Khaitan's case, who was a lawyer too. And now the courts have interpreted it otherwise. There is an amendment which has been made. So every time the defense has found a lacuna or the ability to go for protection either through writ or constitutionality proceedings under the PMLA, promptly there has been an amendment which has come. Now I want to end this because they will have questions with just one, I'm so sorry. With just the Axis Bank reference, which is, so there are two judgments which are relevant. One in context of IBC, where they say that both have primacy and both are equally important and relevant. What it means, I don't understand. But the other is the case of Axis Bank, where the Delhi High Court has said that if it is with the bank, then I'm just trying to come to that. So this is one of the judgments which says supplementary complaint. There's one by Justice Mukta Gupta of Delhi High Court, and they themselves, because every finding or every lacuna which defense has questioned, an amendment has come to the PMLA. Now this Navdeep was, as I said, it was also an important case. Where proceedings for 9 lakhs were passed, were confirmed by adjudicating authority, and the trial was still pending, and it was afterwards trial concluded and they were convicted. The question then being that can the proceedings in PMLA be initiated before? Can the confirmation attain finality even before conviction under the predicate offense? The way the law says, both can go on side by side. The Axis Bank case I've referred to, I think that's really a conclusion of this is the third party claim. This case I thought was relevant because the even though this burden of proof, the court held that the appellant have rebutted the presumption and the charge. So the question is, should there be a presumption? Should some court look whether in such cases can you turn it on its head? In either Nikesh Tarachand or one of the other judgments, the court has said, can you prove the negative? And it's almost impossible to prove the negative. So for that reason, if no other, the burden of proof should not be on the accused. But whether it will at some time be reversed or whether it will remain the same, I cannot say. There have been some 700 odd cases of prosecutions under PMLA in the entire country. Convictions have been not many. I think there have been 13 or 14 convictions so far. But let's see how it goes, because it is an uphill task for the accused, is all I can say. Thank you.
Thank you, ma'am. Ma'am, there are a few questions, ma'am, that I will ask you. The participants have posed it in the Q&A box. Before that, ma'am, everybody is really appreciating your PowerPoint presentation, and we have got demands for sharing the same with them.
Of course, anytime. If you have it, I think you have the...
Yes, ma'am, we have it, but we thought that we'll take your permission first. Ma'am, Mr. Alok Kumar asks a question that, ma'am, why the ratio of Aslam merchant versus competent authority in the judgment of Supreme Court by Justice S.B. Sinha is not being followed while dealing with alternate property being attached. Further, if Justice Garuba's judgment in Axis Bank is read in totality, a third party has a right to prove interest / prior charge over the charged property. When and why it cannot be permitted within the 180 days period, ma'am?
Sorry, would you repeat yourself?
Yes, ma'am. So he asked, there are two parts of the question. First is why the ratio of Aslam merchant versus competent authority judgment of Supreme Court by Justice S.B. Sinha is not being followed while dealing with alternate property being attached.
Actually, it should be followed. I don't see why it's not being followed. The fact is that you need to attach a property, and this option to the accused should always be given, that an alternate property of same value should be allowed to be attached. I don't see why it should not.
Sure, ma'am. And before going to the next question, Mihir, you would like to ask a couple of questions that are posed?
Yes, ma'am. We are getting a large number of questions. So the first one I've got from Mr. Anuj Prakash. He wants to ask that in light of the constitutional safeguards that an accused is not really required to cooperate with the investigating agency, he wants to ask if an accused is outside India and the investigating agency, say ED, writes an email to that accused with certain queries and he responds to the questions, why do investigating agencies still requires accused presence for custodial interrogation?
I agree with him fully. The fact is, these are not cases of custodial interrogation in the first place. Most of it is based on documentary evidence. Most of it is based on letter rogatories, which answers you get from the various investigating agencies, or say from banks, say in the Cayman Islands or in Mauritius, and they are answering you. So the prosecution bases its case on my files, on files which my chartered accountant may give them, from the income tax records, from bank accounts of my near and dear ones through whom I may have money layered, through letter rogatories, and they reply they actually don't need the accused. And then they use the accused to browbeat them to make confessional statements and use them as admissible in view of 50. But unfortunately, apart from police questioning, for all others, the way the courts have been going in criminal law, particularly economic criminal offenses, has been to hold these as admissible. And I don't see why you require any custodial interrogation in these cases. And firstly, leave that. You do custodial interrogation. You're allowed to do a remand for 14 days. After that, why should they remain in jail?
Yeah. We have a live question now, Mr. Alok Kumar. So go ahead and ask the question.
Yeah, good afternoon, ma'am. Good to see you. Hope you're doing fine.
Hi, hello.
Just a quick question elaborating what Mihir had asked you. If you remember that Aslam Merchant judgment of the Sinha, obviously dealt with NDPS, etc. But the ratio there was that, you know, proceed of crime, if it has generated a property, it ought to be attached, etc. And there very reasonably he said that these properties are not part of the proceed of crime. Now, I have been seeing this PMLA since 2009. If you remember, I think you also were part of that litigation of Madhu Koda, where the ED did the first blunder of filing an ECI complaint when the CBI had just not even filed a charge sheet against Vikas Sinha, if you remember that 45 crore rupees. Yes. And when there is no offense under CBI, under the Prevention of Corruption Act, the question came before the court is that how can there be offense under the PMLA? And now, obviously, what I have seen for the ED in the last 7-8 years is that they are allowed to commit a mistake. They're allowed to get away out of it. They become smarter with it. And then they use the learning process in the next matter. Now, Aslam Merchant was a very classic case, and there was also a very good judgment referring to what you had mentioned about this letter regulatory and documentary evidence. I think it was a Delhi High Court judgment that in most of the economic offenses, since it's all document, say for example, I have transferred through RTGS, so unless and until I burn the bank, unless and until I burn their software, etc., or I won't be able to tamper with the evidence sort of thing. So my question specifically is that with this alternate property, and especially now that PMLA has got extraterritorial reach, what would be your suggestion as to challenging the attachment of all and every property of mine, if I am an accused, which actually may hamper my other businesses also?
See, the fact is that insofar as the attachment is done, it's being done by an executive officer, as you yourself know, then thereafter, the adjudicating authority is also confirming. So your first bet is to go, your first opportunity is to go to the appellate authority where there is a possibility that someone may say, yes, this is wrongly being attached. I have seen so many cases where properties are being attached on the face of it wrongly. There is anyway, moment a person's being convicted. So the first aspect, part of what you said, I'll come back to later. But most of those who are being convicted, the bias does change against them. Now, there should not be a bias, because if a property is not tainted, it's not tainted. True. But what I have seen in practice is that the courts somehow tend to go with the prosecution and thereby smother businesses. I've seen that in so many cases where people's properties are Pushtani family properties, having nothing to do with what could possibly be called tainted. And yet it's being done. Now, I felt that Justice Sinha had a very pragmatic approach on this. But the question is, we need to set up a strong jurisprudence on this. And we do not have a strong jurisprudence on it. Both, even under the Criminal Law Amendment Act, I felt the jurisprudence was pro-prosecution. And so has it been that even if they can, and now the law has also, the enactment has, the provisions have been given a wider and still wider cover. So how to prevent it and how to ensure that a person's business doesn't get tainted. See, most courts will not entertain a writ, even though a writ on something like this should be entertained so that you are out of it in a minute. So at the moment you go the adjudicatory and PMLA way and PMLA appellate body, there's so much work pendency before the appellate body and hearings, you know, how many matters come on a hearing. So I feel that to a large extent, it's being unfair on properties owned by a businessman which are untainted. Perhaps the answer is that we start putting fines for attaching wrong properties. There becomes, some amendment is brought in.
I appreciate it. Thank you.
Thank you, sir. Ma'am, another follow-up question to the provisional attachment. Mr. Shyam Mohan wants to ask, can an accused seek directions to ensure that the property attached provisionally remain protected till it is released? Because we have seen that once it's attached, no one takes care of the property, and most of the time, if it's movable, it perishes or it gets destroyed.
I'm sure we can. I haven't looked at it, but there is no reason why you won't be able to ensure that if it's a perishable property, that the commodity be sold and the money saved, put into fixed. All that is possible. All that is possible. What's possible or what could be is somebody attaches and then you have trespassers and you have people vandalizing. That's more likely. The perishable can still be saved. It is what can be vandalized, and that in many attachments, even by banks, I have seen vandalizing by the lay public, and the guards are there only to get their salaries and not do a bit of work. So if it's a steel factory or if it's got iron parts or machine parts, they are all vandalized and destroyed. So I think the best thing is get somehow the other adjudicating authority to make an inventory, get some valuation so that the guards become a little accountable, or it's a case by case, but I've seen that in the biggest of properties, biggest of attachments by banks, by anyone who have even more infrastructure, much more than maybe the ED would have. Even there's vandalization.
Thank you, ma'am. Ma'am, we have a live question from Mr. Avinash. Vaisen, can you please unmute and ask the question?
Yes, ma'am. Thank you for the enlightening lecture, ma'am. Ma'am, my question is that in regards to the fact that the burden of proof is reversed in PMLA cases, do you think that the doctrine of full disclosure, as has been adopted in the West, especially in the US, wherein the prosecution is required to turn over all incriminating and non-incriminating evidence, do you think that could be a possible solution to level the playing field for the accused as well? Because these are a few of the offenses wherein the presumption goes against you, and if you at least have the basics of the entire case against you, then you can put up a defense which is viable.
Yes, but unfortunately, in India, the prosecution does not believe in disclosure and there is no accountability. I think in that Nityanand case, you know, that case where somebody is accused of molestation or rape or something, Supreme Court has recently said that even whatever may be to the defense should be there, maintained properly in the case diary. If I'm not mistaken, that's just come about a year or 2 years ago. That, however, will not be followed according to me.
Thank you, ma'am. Mr. Abhishek Kaushik, can you please unmute yourself and ask the question? Thank you.
Before I ask my question, I want to thank which Mr. Rajkamal has already thanked you, ma'am. The way you have presented this lecture, taking time out on Sunday for us, it's phenomenal. Now,
Thank you.
ma'am, my question is something which you have discussed in the last slide also, and I think you'll agree, that the very essential ingredient to attach a property is that the proceeds of crime must be there. But of late, and in many of the cases we see, the moment an FIR is registered, even before a finding is rendered by a court, the ED attaches the property. Argument was advanced, I think, in Nikesh, and also I think the other case that you mentioned was perhaps Gautam Kundu, where similar arguments were advanced but was not accepted by the court. What should be the recourse available to such an accused? Here, because decision has not been rendered that the money is tainted or that it is proceeds of the crime, it's still at the FIR stage, but the ED has proceeded, attached the property, and there will be no disattachment. And second question, ma'am, is, second question would be in an analogous situation where a perfect bona fide transaction happens, but the money that has been paid by a person is thereafter found to be a tainted money. Like I may be a jeweler and I have sold goods worth 10 lakh, completely genuine transaction. I have given the receipt, GST, tax, etc. is paid. But tomorrow can ED then come after my life to say that, look here, the money, the transaction might have been genuine, but the money that has been paid is proceeds of crime, and therefore I am going to attach that money also, which is parked in your account.
See, that Axis Bank case is very clear, because in that's exactly what happened. That ED said that the property which is given to Axis Bank was property which was tainted, and it was given to Axis Bank as a collateral security for a loan taken, and Axis claimed it. They said, you are a bona fide purchaser. So according to me, such a person should be able to get off the net. But till you get off the net, you have to, I mean, you see cases where
exact problem
you prosecute some 500 appearances before the appellate tribunal.
Good for us, but the client suffers.
Yes. I'm talking of the client. I'm talking of the client. The client suffers. Now, your other question was what? See, in India, we do not punish for wrongful arrest or fine. In India, we do not fine for the loss that is caused. Why do businesses go so bankrupt? Loss is caused, and then a bank will go shrug its shoulders and walk off. It won't have anything to do, and the courts will not even look at it. And the way we look at this is there's too much litigation, so we can't fight for malicious prosecution. But the moment that you start doing that, ED will stop attaching wrongfully. You know, it will attach carefully. So the question is, if one does one such sample cases, you will avoid wrongful attachment in 10. So it's better to increase litigation to decrease litigation in the long run.
Thank you, ma'am. Ma'am, we have another query from Mr. Simon Benjamin. He asks a question that, ma'am, please give your opinion regarding the conflict under the PMLA between the sovereign authority of the state to seize, confiscate a property which has been acquired by a person through criminal activity, as against the lawful claim of an innocent third party to recover the same property.
So I thought, Simon, the answer to your question was the Axis Bank answer. So it's basically if you are innocent, but the way the language PMLA is, after its amendment used, is a very broad language. Perhaps this will come up for interpretation again, because what they are virtually trying to bring is even properties where the person is completely bona fide and has purchased. But whatever it is, that judgment, the judgment of Justice Gorba's bench in that Axis Bank case will stand in your favor. In fact, there will be judgments relating to DRAT and Sarfasi proceedings, which will also have the same effect, where somebody has taken something bona fide. I think all those judgments, apart from Axis Bank judgment, should come in to your rescue.
Thank you, ma'am. Ma'am, Dr. Madhukar Sharma asked a question which you had also mentioned in your lecture, that so far there are only 13 convictions in the PMLA since its enactment. Ma'am, what would be the reason for such poor conviction, and what could be the way forward for it, ma'am?
See, according to me, and maybe I'm the persons who are prosecuting or who are doing cases under PMLA, who are the investigating officers, are mostly deputationists to my mind. I may be mistaken. Many from customs, income tax, very few from the police. I feel people who are specially trained from the police and should be doing these investigations, and the sole ground or basis should not be admissions by the accused. You can't base your prosecution case on basis of admissions, and you can't stretch your case to illogical limits. See, the problem with enforcement directorate cases is that there is a complex web of cases of money laundering. But if I make 2 + 2 as 8 and I don't get a conviction, then I don't deserve a conviction. So I have to get conviction, I have to ensure that my investigation is not over padding or overreaching. I always find it very impressive that there was, we were in some legal forum and discussing, and one of the judicial officers, not from India, from another country, was being asked, how do I increase, or how do you increase your rate of conviction? And he said, first tell me, how do you improve the quality of your investigation? So the moment you improve the quality of your investigation, your rate of conviction will go up, and rightly. I don't want to convict wrong people.
Thank you, ma'am. Ma'am, we have a live question coming in from Dr. Madhukar Sharma. Sir, could you ask your question, please?
Good afternoon, ma'am.
Good afternoon.
Ma'am, it is in continuation of the question or the suggestion that you were giving, because the thing is that it is a complaint case trial. One of the questions that I have posted in the QA box was this one as well, or I failed to post it maybe. That why because when we make it to be a complaint case trial, it becomes very complex, not only for the investigation agency as well as for the prosecution as well as for the trial courts as well. So should we make it to be completely investigated by the police agencies? My first question is this, ma'am. And second is this, that because it was pointed out by you that custodial interrogation is not required. So when, ma'am, custodial interrogation is not required, why the offense committed under PMLA is made non-bailable offense?
See, an offense may be non-bailable and yet you may get bail in it. The question is, why is it made non-bailable? Because there will be cases where you may require custodial interrogation. When I say it's not required, I may mean that it's not required in, say, 60 or 70% cases. I can't say for certainty that it's never required. I've also come across people who say that some of the officers are not so trained that they will be able to take out the money trail, which is so complex. So what they do is they use the custodial interrogation or the statements to complete the gaps in their trail, which they are not understanding. I mean, their job is to know their whole case. Their job is not to depend on the accused to fill their lacunas in the case. So to answer your question, it's not required. Ultimately, I'm not the legislature. If I was the legislature, I may actually be thinking whether it should be made non-bailable. But having said that, it is not that you arrest in every case of non-bailable offenses. That's what D.K. Basu says. That's what Joginder Kumar says. All these judgments really say, am I right? I think it's Joginder Kumar, not Joginder Singh, but Joginder something. So all these cases really are saying to have the right to arrest doesn't mean that you have to arrest. Also, so the question is, it shouldn't be the norm. The other aspect, should it be done by police officers? I feel that the police is more trained than these people. I feel the police is also more answerable to the courts. I feel the police is more sensitive. And you may find this shocking because most people don't have this view of the police, but I think they are more vulnerable to the courts. So they'll be more careful of following the right processes, because when they go on deputation, they don't forget that their training. So that's what I think. Every person who's meant to join the enforcement directorate should be given training as to principles of natural justice, judicial principles, principles of being careful about proper disclosure, and about the investigation being based on their hard work and not on base of admissions and statements of the accused. So that's what I feel about it.
Thank you, ma'am.
Thank you. Ma'am, there's one question from a participant, Devasmita Sarkar. I will ask the query, I'll quote it, ma'am. that why have offences under Income Tax Act, Sales Tax and Excise Evasion not been included as proceed of crime in the scheduled offence under the PMLA Act?
So, Asmita, I think that most of these should not be included. According to me, your purpose in life is not to create parallel prosecution for one accused. Why was this FATF started? Why was this international cooperation done? It is principally for two purposes. One, terrorist activity, organized crime. Organized crime to the nature of drug trafficking, which takes into ambit crores and crores of rupees. It was not to get cheating cases, prevention of of corruption cases. There are already enactments for that. Why bring them into double cases? There was a purpose. They needed international cooperation on terrorist crime. They needed it on these drug cartels which operate internationally. So that's the purpose. We are losing the purpose and taking away fundamental rights of a person just by putting them under PMLA and another enactment. To my mind, this is not the purpose.
Thank you, ma'am. Ma'am, there's another question. I'll just quote, ma'am. From the participant Tanish Rawat, and the question is, ma'am, that there are so many auction houses like Sotheby's and Christie's which sell arts, jewelries, and watches worth hundreds of millions in auction, and they do not disclose the name of the buyer, stating certain reasons to protect the privacy. Ma'am, in such cases also, these expensive products can be used to launder money. So, what do you suggest? What could be the outlook, and how can we bring this also within the purview of PMLA?
See, fact is, we have to balance two rights. All of criminal law is balancing two rights: the rights of an individual and the rights of the public. So I'm sure Christie's and Sotheby's, if they are faced by an Interpol question with regard to a serious money laundering case, they will disclose the source and the name. Otherwise, there is no reason why they should disclose the source and the name.
Thank you, ma'am. Ma'am, another question by Professor Meera Matthew. I'll quote. The question mainly involves the definition of proceed of crime, which after the amendment it says directly or indirectly, like you have presented it in the slides, ma'am. So, do you think this is a legislative overreach because it's giving the authority undue power, especially when the term any criminal activity is not defined anywhere?
I think the amendments in the PMLA are to some extent overreach. I think all of law has to be well thought out, and we had the enactments in various countries before us when we enacted in 2002, which came into force in 2005 and became an act in 2003. So we had all these enactments. Why should we need to make, I think, amendments so many times? I know 13, I know 18. I think we've had 2 other amendments, if I'm not mistaken. You don't need so many amendments. And in every amendment, we are increasing the scope and making it more and more vague and more encompassing. That's not what law should be about. For all people to carry on business, to carry on their professions, there has to be an element of certainty, and I believe sections and provisions should also be very crisply defined.
Thank you, ma'am. Ma'am, we have another query from participant Mr. Bhavraj Singh. His question is, ma'am, that in a pre-existing case on the basis of which a PMLA case is registered, that pre-existing case, if gets settled, will the PMLA also cease to exist, or is it an independent proceeding and will continue?
It's an independent proceeding and it can continue. It's very unusual, but I see in the US lots of the money laundering cases getting settled between the state. And I don't think that would even be permissible in India. But there they are settling lots of the cases, including cases against officials or bank officials or companies. And that to me should to some extent be the purpose in economic offenses. I'm not talking of heinous criminal offenses. I'm talking of economic offenses, because the idea is to bring home the fact that this money has been laundered and should return to the state. So if it's possible, many could possibly be settled. Question is a larger question. When Mr. Chidambaram spoke in the floor of Parliament, that should they be cognizable, should they be bailable, should they not be? So this is perhaps a larger debate.
Thank you, ma'am. Ma'am, we'll take the last question for the day. And ma'am, this is in continuation to what Dr. Madhukar Sharma had asked earlier, that there are only 13% of conviction, 13 conviction in PMLA. Now, the other question which the participant, Mr. Manan Sanghai, asks is ma'am, that the trials take place at the bullock cart space. What can be done to make it a little faster, the cases that are being taken up by the courts?
See, I tell you, PMLA courts are not overburdened. There are very few courts and they're not overburdened. So it's not at a bullock cart pace. We can talk of other cases, we talk of this. So what happens sometimes, I have seen Enforcement Directorate, it's sometimes trigger happy. Without doing its full investigation, it files a case. Then it doesn't want to prosecute the case because it wants to file a supplementary complaint. There was no provision for supplementary complaint, but it's now been interpreted by 2 high courts and they themselves have brought in some kind of amendment in it. So if I file 10 supplementary complaints, how will your case progress? All you'll do is you'll sit with provisional attachment orders and you will sit with arresting people. That's the problem.
Thank you so much, ma'am. Ma'am, now thank you so much for such an intense, thoroughly researched, and in a systematic way, you've explained everything about PMLA within the time frame that we had. Now, I'll please invite Dr. Professor C.J. Ravanle, sir, to make the concluding remark, and after that, Mr. Kumar Mihir can extend the vote of thanks. Sir, over to you.
Ma'am, thank you very much. As usual, you delivered another session. And one doubt which I used to have, why law is called as draconian law, because we were taught in the school that beauty lies in simplicity. And laws never have been simple, or they have been written so differently that people find it difficult to even read the law. Of course, understanding the law for a few would not be the thought which may touch their mind. But there are few observations which I was making while listening to your speech. Even the term called black money, because we were taught in schools that when it comes to money, then you earn money or you make money. So earn money, we were taught that it is ethical way. Make money, it's unethical. But when it comes to law, we do not find that distinction at all, because anything can be labeled as, and we have names which do not find place within the legislation as well. What is black money? What is white money? Because what you procure permitted by law, I think that is what is called as it's your earning, and what you do against the law is making the money. But you do not find that being so defined. Then we also go to the terminologies, like you rightfully touched the topic that the presumption of innocence is given a toss when it comes to the legislations like the Prevention of Money Laundering Act. And you also referred to the judgment, the Nikesh Tarachand Shah versus Union of India, because section 45 clause 1, which required the two condition requirement respect to the bail, and the two conditions were like the public prosecutor must be given an opportunity to oppose any application for release on bail, and the court must be satisfied. And here comes the important aspect, that the accused is not guilty of such offense, that he is not likely to commit any offense on bail. I mean, there is no presumption of innocence. Rather, we begin on the premise that the person has committed or we have declared. So the bail and the Honorable Supreme Court. And if we go to the bill which was introduced before the Parliament and wherein this section was read, it was very clear, because the bill mentioned that bill referred only to offences under the Act. And when the Act came into being, rather it went other way and it changed it. So the Supreme Court had to declare this provision to be unconstitutional. And then ordinance was brought. That is another aspect which we see, and they tried to correct it, which would have been done, and we did not require the intervention. And here, then the school of American realism or the legal realism becomes important, because John Gray says law will remain in womb, mother's womb, if not judged by the courts. And that's why PMLA, people may say there is less conviction rate, but we also have to go back to section 40 of the Indian Penal Code, because it is very specific. It defines the term offense. Again, not simple provision, thing made punishable by the code, and then further acts of special act, other act, etc., etc. And then we find reference to the Prevention of the Money Laundering Act as such there too. And we also have to understand that it is, I understand money laundering as an auxiliary offense. This is not original, rather something is done and then what it follows as an auxiliary offense may be referred as. But we cannot deny the role of the agencies. And if agencies do not do their job, and you rightfully said it is a predicate offense oriented law. This means a case under the Act depends on the fate of cases pursued by primary agencies. And we don't have to talk about the agencies, whether they get used, whether means they do their job, or whether they are asked to do the job. So there is the difference which also comes into being. So instead of being a political etc., but the intervention of the courts and the role of good advocates like you become more important. Because PMLA needs to be understood by many. Many may say it's a draconian provision, etc., etc., but said to be an attempt to take care of offenses which were not so suitably dealt, but still it lacks lots of procedure. And there is, I feel that there is lacuna in the substantive law as well. And like to begin with presumption of innocence, the Constitution talks about the fundamental right, but herein you make one incriminate himself or herself. Means the provision directly does not say, indirectly does not, but you read as you wanted, and accordingly I quote, fix and unquote the person as you want, and then the things go. But still we believe in the justice, administration of justice. And there is a good movement that the criminal laws of the land would be given another look over. Hope so that the basic principles of criminal law will remain untouched, and which would talk in favor of the individual, whom we call as the citizen, and accordingly the state will do everything to protect the rights of the citizen. Hope so. And of course, we'll give the benefit of doubt to the Prevention of Money Laundering Act in this case as well. There is an attempt, and of course they are doing well. Let us hope so. And thank you very much, ma'am. As Rajkamal said, I was reading few of the comments as well. As always, you come not well prepared. You always are well prepared, but you present it so well that people who do not have, may not have heard of it, but they also try to listen to, learn from it, and you relate it with the cases which are so taking place. And as a result, because people hear that and you relate and you take it to the right notion of the law, and we like that as well. And there was a doubt which was raised whether PMLA is used as one more weapon against the persons who may not like one's ideas or other. Well, law always has been used or always has been misused, maybe the cases. So PMLA cannot be an exception. So intent of law cannot be challenged. Intent of law always is good. How one takes it or uses it decides the fate of that act. So not the legislation. So with this humble submission, I would like to thank you once again, ma'am. Thank you very much. Over to you, Mihir.
Thank you, sir. I would once again like to thank ma'am for presenting this lecture and making the concept of PMLA Act understood by all of us, especially on a Sunday afternoon where I'm sure she's getting late for her lunch. So thank you, ma'am. And once things normalize, we would like to see you again in our college and hear from you personally on many more topics. I would also like to thank our partners in this endeavor, Lex Witness, THS, the law firm, Sadgamaya, and Symbiosis Law School. I would especially like to thank our professor, teacher, and mentor, Professor Dr. C.J. Ravandle, without whose guidance this endeavor would not have been possible. I would like to thank the moderator for today's session, Mr. Rajkamal. And last but not the least, I would like to thank all the participants for giving us their support and taking time out on a Sunday afternoon to hear ma'am. I would request them to register for next week's sessions as well. The details will be shared with them in some time. The video of today's session is available on the YouTube channel of Symbiosis Law School. So if you want to go back and hear ma'am again, you can visit the YouTube channel and hear that. Thank you, everyone. Have a nice day. Thanks a lot, ma'am.
Thank you so much.
Thank you, ma'am. Thank you.
Over